Hello and welcome to today's latest offering of continuing professional education. I'm Mitch Orpit from the law firm of Tribler, Orpit and Meyer in Chicago, and currently chair of Eagle International Associates. This webinar is brought to you by Eagle and is just one of a series of conferences and panel discussions dealing with important issues and challenges of significance to claims professionals and defense lawyers around the world. We're really delighted that you've joined us today for this program. Before we begin, let me give you a quick word about Eagle and who we are, and point you to some additional resources that we have available for you. Eagle is an association of defense lawyers and insurance adjusters throughout the United States, Canada, and parts of Western Europe. After review, we admit one or two members from firms in each of the various states and provinces and from other countries. We all work with insurance companies, corporate litigation departments, and risk managers, and devote most of our practice to the service of companies and their insureds in defense of claims. Eagle members are dedicated to the service of the insurance industry, to providing highest quality professional service, and offering additional value to our clients through sharing our resources, offering 5 or 6 live conferences a year when safety permits us to do so, and when it doesn't, to offering programs like this on a remote basis when people can't travel or we can't gather together safely. We also publish articles several times a year and have compendiums and publications that deal with national surveys on important issues. One such example of the publications that we have would be a bad faith compendium where you can click online, get to a specific jurisdiction, and be brought into a discussion of the governing law in that area with links available to the statutes that may govern your claim. So if you visit us at our website, which is www.eagle-law.com, you can find listings of programs such as this, some of the other remote programs that we're doing, and also of the various publications we have that are available to you. You could also click on and get to know the firms who are members of Eagles, the individuals who are active in the organization, who we are, what we do, where we're located. We're happy to talk to you. Our Eagle members are happy to talk to you. So feel free, if you have a question, you need help finding somebody or something, give us a call. We're happy to address, or send us an email. And we're confident that through our vast network, we can help you find solutions to problems and get you answers to whatever questions you may have. Again, that website is www.eagle-law.com. So again, thanks today for joining us. We hope you enjoy the program. And I will turn you over at this point. I should add one other thing. In addition to the live programs that we do in various spots around the country, one of the services that we have offered in the past and continue to do so are programs specifically for a client or a company. So if you have an issue that you would love to see us come in and have us address for you or your colleagues at your company, we're happy to do so. We come from around the country, happy to visit with you and share items and issues for discussion, put on panel programs, and deal directly with you. If you have any thoughts along those lines, feel free to contact me, our Executive Director, Terry Napolitani, or any Eagle member listed in the webpage, and we'll be happy to talk with you about that. So again, thanks for joining us. Enjoy the program. And I will now turn you over to our conferences chair, Lindsay Woodrow from the Waldeck firm in Minnesota. Waldeck firm is our Eagle member for the states of Minnesota and Wisconsin. Lindsay.
Thanks, Mitch. As Mitch just mentioned, I am the Eagle Conferences Chair this year, and I want to welcome you to Eagle's webinar platform. We hope that you find this informative and useful. This particular webinar was part of a longer 5-hour in-house seminar that we put together for an insurance company. So you may see and hear some glitches or references to other subjects or other panels. and discussions that took place. We certainly apologize for that, but we thought that the content was good in the program, and we wanted to bring this to you broken down into separate webinars so that you have the opportunity to pick and choose what's relevant to your work and to your interests. So with that, let's get to the webinar that you all clicked on today. The title is Charity is a Virtue, but Increasingly Not an Immunity to Liability. For you today, we've got three great Eagle members. The first is David Hudson, who's our Eagle member from Ohio. Shea Backus is going to join us. She is our Eagle member from Nevada. And then David McDonald, our Eagle member from Texas. So with that, I am going to turn it over to your panelists. We hope you enjoy.
My name is David Hudson from the Reminger firm in Ohio. I am the panel chair for this aspect of the presentation. My co-presenters, actually, for this particular panel, the closer is Shea Backus from the law firm of Backus, Carranza, and Burden in Las Vegas, Nevada. Shea, are you with me? Well, hopefully she'll log on if she's not here with us now. And the other presenter is David McDonald from the law firm of McDonald, Devin in Dallas, Texas. And hopefully, I don't see David yet, but hopefully he's on as well. I know that I speak for both of these folks in thanking you for allowing us to present on this topic today. And there's David. I'm going to start in true lawyer fashion with a disclaimer, but the funny thing is, as I was listening to this presentation this morning, I thought I should bring it full circle. This disclaimer happens to be our reservation of right to beat back the bias that we actually know all the answers on this topic, because we don't. And I had to smile a little bit when Kelly was talking earlier about bias because she mentioned that her clients sometimes assume that she understands the topics. And I think that's a matter of perspective, because I think oftentimes the other opposite is also true for us, which is, as lawyers, folks assume that we know what we're talking about all the time, and that's not always the case. So I had a good morning self-reflecting, and hopefully there was a moment of levity for you folks as there was for me. But as it relates to this disclaimer, as you're going to see from our presentation on charitable immunity, in 2020, it's really the exception as opposed to the rule. The application of the doctrine continues to be narrowed, even for the states that have some continued immunity for charitable organizations. Our presentation today on charitable immunity is really broken up into three segments. I have probably the most boring segment, which is a general overview of the background and historic origin of the doctrine, which is simply intended to help give you folks a better understanding of how the law of charitable immunity developed and how we ended up where we are today. David McDonald will then pick up and take off and discuss actually the topic of charitable immunity in Texas, which I think will include a very interesting and detailed discussion about how to invoke the application of the doctrine under Texas law. And then Shea will conclude the presentation with a very current and interesting topic on the discussion and application of immunity in light of COVID-19 in the year 2020. And so to get us started, this concept of charitable immunity was created in the mid-1800s. It was applied in the US about 30 years later. And essentially, charitable immunity is an exception to the general rule of tort law, which would ordinarily place liability on the person or entity who's responsible for the tortious conduct. There were really two main theories behind the origin of the doctrine. The first was this trust theory that you see on the slide. And the trust theory was based on the concept that charities are designed to hold money for distribution to others. If a tort plaintiff is awarded money damages from a charity, then the funds that were intended for distribution are no longer available to the persons who need it most. So the idea is that the charity is really holding funds for others. The second rationale comes at the bottom of the slide relating to the implied waiver theory. The implied waiver theory, which in fact we'll still see some remnants of today, is the concept that any person who accepts the benefits conferred by a charity has also impliedly waived the right to sue the charity for damages for any negligence or harm in rendering those charitable services. And you'll see in a minute that part of that doctrine does still apply in some states. But really the presumption underlying these theories, and frankly the doctrine as a whole, is this basic idea that charities will have good people doing good things. And of course, in our business, we know that's not always the case. And for that reason, over time, there began to be a shift in the states away from the concept of absolute immunity for charities over time. And because I have the background, I decided to try and add some humor to this. If you understand this meme and find it funny, that's perfect. And if you don't, I'm skipping over it quickly and you'll never know that it was there. Moving forward in the mid-1900s, there was a shift in the application of the doctrine of charitable immunity away from complete immunity for charities, and the trust and implied waiver theories began to fall out of favor in what I'll refer to as an infamous opinion by Judge Rutledge involving Georgetown College. And in this case, involving Georgetown College, a nurse was struck by a door that had been pushed open by another student nurse. As a result of this incident, the nurse had some permanent injuries, and the hospital was a charitable organization. And the unique aspect, of course, is that it was not an injury to a beneficiary, but actually an injury to another one of its agents or workers. And of course, Georgetown College sought to invoke the doctrine of charitable immunity as a defense to the claim. In reaching his decision, Judge Rutledge essentially rejected the theories behind charitable immunity, finding that the entirety of the doctrine was inherently unfair. And this was sort of the beginning of what proved to be the end of broad-based charitable immunity. And there were a number of reasons for his decision, but perhaps the two that stand out the most in today's case law is, one, that immunity to charitable organizations provides no deterrent effect for wrongdoers and bad actors. And two, immunity improperly places a burden on the victim of the tortious conduct. And the essence of the holding was that a charitable organization should have no greater immunity under the law than any other defendant. So the Georgetown decision by Judge Rutledge led to the development of a new mindset on immunity. And conceptually, the courts latched on to the fact that immunity needed to be limited so as to deter wrongful conduct. And the primary idea behind this policy shift was that if the performance of a duty must be done, it must be done with reasonable care. And that is true without regard to the charitable motives of the organization. The second policy idea was to ensure that victims were compensated for their tortious conduct. And of course, these are primarily the main points of the Judge Rutledge decision, and they're the same policy objectives that we continue to see today with regard to the limited application of charitable immunity across the United States. Now, there are a variety of circumstances that immunity still exists. We're going to talk about some of them today, but the important point to take away is that no state provides full immunity for charities. Every state that affords some type of charitable immunity today also limits the application of the doctrine. And additionally, the burden of proof is on the charity to establish its application. This particular chart identifies 9 states that have some form of charitable immunity. Alabama, for example, has immunity only for claims that are asserted by beneficiaries of the charity. And again, this takes us back to the implied waiver theory, and this is where we see that following through today. By contrast, if you look at Maryland, Maryland provides immunity to a charity, but only if it holds all of its assets in trust and does not carry liability insurance. Obviously, the Maryland provision seems a little counterintuitive, but hopefully this chart exemplifies the lack of uniformity in the application of the doctrine in the 9 states that have some form of limited immunity. This slide actually represents 4 states that have caps on damages against charities. I'm not going to spend any time on this because my colleague David McDonald is going to explain Texas and its cap in some detail. But I think the moral of the story here is that the application of the doctrine is extremely state specific. And so as of 2020, we're looking at essentially 13 states with some form of limited immunity to charitable organizations. And there's a handful of other related limitations on liability. Tennessee law protects property from judgments that could attach to a charity-owned property if that property is exclusively used for charitable purposes. Maybe the most interesting is this Massachusetts law that has immunity for charitable sport and sailing programs. So for all the boaters out there today, Massachusetts is your state of choice. This slide I put in, again, for some humor because I have such a tough topic in the background, but it's kind of funny to me, but it's good for a laugh. It's actually not true. All 50 states do offer some sort of protection for Good Samaritans who offer emergency medical assistance, and that would include medical professionals and doctors. So although it's funny, it's actually not true. And immunity for volunteers is the last topic that I'm going to touch on in terms of background. And the Federal Volunteer Protection Act does not apply to an organization, only to volunteers. To qualify, the volunteer must be licensed, they must be performing work within the scope of their responsibilities as a volunteer, and may not receive compensation in excess of $500. The Act does not apply to the operation of motor vehicles, gross negligence, willful and wanton misconduct. So with that background and overview on the law of charitable immunity, I'm going to turn this presentation over to David McDonald for what I will describe to you as a more interesting discussion on the application of charitable immunity in Texas and how to invoke that protection. So David, you're up.
All right. Thank you, David. Can everybody hear me? Can you hear me, David?
Yes, I can.
Okay, great. Good morning, everyone. I'm going to talk about charitable immunity in the state of Texas. And when I refer to the statute or the code throughout my presentation, I'm really referring to the charitable immunity of Chapter 84 of the Civil Practices and Remedies Code of Texas. It was passed in 1987. And the intent was that it would provide limited immunity to charitable organizations to reduce liability exposure, insurance costs. And the key here is limited immunity. There is a perception that if there is charitable immunity in the state of Texas, that applies to all religious organizations or exempt organizations. But that's not necessarily the case, and we'll talk about that today. The Act applies to many different types of businesses and organizations, but my presentation today will function on and discuss religious organizations and charitable organizations because of the audience that we have. It is a very encompassing statute, so this is not presentation today is limited with regards to those two organizations. So this statute applies to any organization that is exempt under the Federal Income Tax Code, 501c3, which is really a no-brainer. But it also applies to a bona fide charitable organization, a religious organization, and then in the statute it lists a number of different other organizations, which I omitted, or an organization that's organized and operated exclusively to promote social welfare by being primarily engaged in promoting the common good and general welfare of people in the community. It is further if it's organized and operated exclusively for one or more of the following purposes. Does not allow any part of its net assets to be on dissolution, the organization to benefit any select group, shareholder, or individual. Normally receives more than 1/3 of its support each year from different grants, or contributions, or membership fees. Not directly or indirectly participate or intervene in political campaigns, are in opposition to any candidate to public office. If you remember, that became an issue with regards to some churches in connection with the last election as to who they were endorsing. And there was a threat by the IRS that they may jeopardize their charitable organization status. And it dedicates its assets to achieving the stated purpose of the organization and does not engage in activities which are not in furtherance of its general organizational purposes. So what is a religious organization? So when you consider in Texas, there is somewhere, based on the last count, which was, I believe, in 2000, there is somewhere in the vicinity of about 30,000 to 45,000 registered churches in the state of Texas. And there are over 100,000 charitable organizations under 501c3. So the term religious organization includes organizations whose primary purposes are religious in nature. However, the Internal Revenue Code doesn't necessarily define that. So you have to look to the courts. And we'll discuss this later on in my presentation. There's very little case law in the state of Texas that interprets this encompassing statute. So you really have to end up looking to other states, or you look to federal court cases. So the question with regards to the courts consider what is religious in the context is whether or not there is a belief, which is a religious belief. And the Supreme Court considered that question, and ultimately they relied on a theologian and Paul Tillich, and whether or not the particular church is in their belief is their ultimate concern, which really doesn't give us much guidance. But if you look towards the case of the Foundation of Human Understanding versus the Commissioner, which I've given you the site there in the tax court, they seem to look to 14 particular factors in determining whether or not an organization is actually a religious organization. And these are typically not cases or churches that are in mainstream, but they're typically cases, if you're defending them, a particular church that may be outside of mainstream. So if you have a plaintiff's attorney that's attacking the case from the standpoint that the charitable immunity cap is not applicable because it's not a religious organization, these are some of the things that you look for in determining whether or not the cap applies and whether the organization is actually a religious organization. So the first one is it's a distinct legal existence. It recognizes a creed, a form of worship. It's a defined, distinct ecclesiastical government. There's a formal code of doctrine and discipline, distinct religious history, membership not associated with another church, organization of ordained ministers. Go to the next one. Ordination after prescribed studies, literature of its own, established place of worship as regular congregations, regular worship services, Sunday schools, or religious for instructions of the young, in schools for preparation of ministers. Now, not all of these are necessary. Those are just some of the factors they look for with regards to the test. Now, there is an exception. So there is an exception under Section 84.007 of the Act, which we'll talk about more specifically. But if there's any civil action brought against a non-hospital charitable organization, which has its own separate cap under the Texas Medical Liability Act, for damages based on an act or omission by the organization or its employees or volunteers, the liability of the organization is limited to money damages in the amount of $500,000 for each person and $1 million for each single occurrence of bodily injury or death, and $100,000 for each single occurrence for injury or the destruction of property. But there's a caveat to that. There is a requirement that the religious organization have insurance in place to cover these acts and omissions of the organizations and its employees and volunteers in an amount of at least, and I want to emphasize the word at least, because that issue is starting to become prevalent in the pleadings in the last 3 years, particularly since the Me Too movement, which we'll discuss a little later. So the insurance has to be in place, which coincides with the cap, 500,000 for each person, 100,000 for each signal occurrence for bodily injury or death, and 100,000 for each single occurrence for injury to or destruction to property. That can be through a self-insured retention, through a Lloyd's syndicate, or through an online, qualified insurance company. So let's talk about non-liability for disclosing sexual misconduct. This is a pretty shocking, in my opinion, immunity. And this was added later after the original act was passed in 1987. And I thought this was important to discuss this because I've handled a number of cases in which there's been lawsuits that have been filed against churches for information and religious organizations for information that they have disclosed when they have been contacted by past employees, employers, and they have disclosed information, and there's been significant litigation about that issue. Charitable organization or an employee, volunteer, or an independent contractor of a charitable organization acting in good faith is immune from civil liability for any act to disclose to the individual's current or prospective employer information reasonably believed. That's a very low threshold. Reasonably believed to be true about an allegation. It's not even truthful, it's just an allegation that an individual who is employed by or served as a volunteer, independent contractor of a charitable organization or its associated charitable organizations, they are immune if that individual, if that allegation was that individual engaged in sexual misconduct, sexually abused another individual, sexually harassed another individual, committed an offense under certain sections of the penal code having to do with sex trafficking, sex assault, sex offenses, public indecency, sexual abuse, or sexual harassment. Now that threshold, which I talked about just a few minutes ago, doesn't mean a conviction, doesn't mean that there was an investigation. Test is, do they reasonably believe in good faith? So that is a very encompassing immunity privilege that is applicable to charitable organizations and 501c3s in the state of Texas. And it's becoming increasingly objectionable. So what is an employee as it's defined under the statute? An employee means any person, including any officer, director, who is in a paid service of the charitable organization, but does not include an independent contractor. That person has to be not engaged in activities that are not in furtherance for the purpose of the organization. So basically the test is the employee has to be typically within the course and scope of their employment. And they have to be acting in such a way that it's in furtherance of the organization. Volunteer liability. This is always an issue that's discussed because so many members of the church are in the volunteer category that may be subject to potential liability, such as if they're on a church outing and parents were chaperones and either an assault took place or some type of tort. So whether or not that parent is actually comes under the act, this section is applicable, and that's typically how we invoke this section. So it defines a volunteer liability except as provided in Section D, which we'll talk about. Section 84.07, a volunteer of a charitable organization is immune from civil liability for any act or omission resulting in death, damage, or injury. Once again, if the volunteer is acting within the course and scope of their employee employment. So that is that is an important aspect of the statute. Now, there's limitations to this, which I'm going to spend some time on today, because when I talk to insurance companies, they typically take the position that the first thing they want to find out is this a charitable organization? Is it a church? Does it come under 501c3? We have an absolute defense. Well, from a practical standpoint, when the insurance company is doing the underwriting, that should be asked in the questions. Are they a charitable organization? Are they a typical 501c3 in which they've actually filed their documents and made that declaration with the Secretary of State in the state of Texas? However, all those issues which I talked about in tort, in which the Act applies, it does not apply if the plaintiff alleges or can prove intentional conduct, willful negligent, or done with reckless indifference or reckless disregard for the safety of others. Now, in the last 4 years, the plaintiff's attorneys are starting to allege, either in their original petition or they're in their amended petition after they've conducted certain amount of discovery, they're pleading around the Act. And it's causing a significant amount of pain for a number of the clients and the insurance companies, because despite the fact that we have over 450 state courts in the state of Texas, 13 appellate courts, we don't have one appellate decision interpreting the charitable immunity application and how it applies, which we're going to discuss a little bit later concerning the limits, which is a real serious potential pothole for us. The chapter does not apply or modify the duties or liabilities of a member of a board of directors or officer of the organization to the other members as shareholders. So if there is a charitable organization and they have a significant amount of money and there's some allegation that that money is not being used and there's a breach of fiduciary obligation, the other members can certainly, if they have standing, can bring suit, and the Charitable Immunity Act cannot be invoked. There's no limitation. The chapter does not limit the organization or its employees and volunteers if the purpose of the organization is formed just to limit liability. So that organization would have to comply with all the other 501c3 tests and religious tests. And for some reason, number 4, the legislature included an exception that if the chapter does not apply to organizations formed to dispose and remove hazardous waste as defined under the applicable statute and federal law. I really can't tell you about that. I've never really had to address that, but it's a little unusual. All right, so the Charitable Immunity Act in Texas only applies to personal injury, tort, and property damage. It does not apply to claims for breach of contract, slander, discrimination, and liability. So let's talk about that for a little bit. I think this is best described through an example. We have 2 cases that are pending now that are against religious schools that are associated with a church. And they're for multiple victims of sexual assault. So these students, their parents paid tuition. So there's the normal causes of action in tort. And then there are additional claims for breach of contract and discrimination, which clearly attempt to plead outside the charitable immunity caps. This creates a real issue for a number of different reasons. You might have, for instance, the headmaster and some particular teachers that are named individually. So then it creates an issue of a potential conflict between the school and the individuals. So the insurance company is then required to hire separate counsel in those circumstances for the headmaster or the individuals, and then a separate attorney for the charitable organization. And we're in the process of doing that right now on 2 cases, and it creates some real challenges for us in the defense of the case. The other thing from a practical standpoint is that how do you plead this and how do you use the Charitable Immunity Act? So typically what we do is if we can figure out early on, either by the documents or they've got counsel that's available, how do we actually, how do we invoke the act? Well, it's an affirmative defense. When we plead it, the burden shifts to us to satisfy, us being the defendant, to satisfy the requirements of the act. So you talk to your insured. That's a religious organization in the school, and they're not experts on that. So what we do, and we've learned over the years, that I hire an expert. It's typically a professor at one of the law schools in Texas who specializes in charitable immunities. They're hired on a consulting basis, and I introduce them to the insured, and I provide all the information that that expert would need to have to make the determination, the same as a court or the IRS, as to whether they're a charitable organization or a religious organization. In some instances, they want to look at their profit and loss statement. They may want to look at how much money they give to charity, what they do. And many times there's a 2 or 3 page list of questions that the consulting expert will want to see. Sometimes they'll actually want to go to the church and see it and introduce them. So, so the practical aspect of that is that that relieves the burden from your insured to have to explain the charitable organization. Our consulting expert, who's much more adept to that, will do that. So in the past, what I have done is that I have filed on a pretrial motion, a gatekeeping statute or a gatekeeping type motion, asking the court to make a pretrial determination that the statutory caps are applicable to the case. On each occasion, I'm sad to say that I've been overruled by the court, so I don't do that anymore. The court's made the decision that the way the case is pled, and the plaintiff in each case came up with some degree of scintilla of evidence of potential punitive damages or gross negligence to circumvent the cap. The court has ruled that that is a post-verdict motion. So, and so what happens is after the case is tried, our expert, who will talk about charitable immunity, it also is very effective from our standpoint because he can be an independent, he can be seen potentially by the jury as an independent spokesman for the church or the charitable organization as to what their mission is and what they do. And he's able to do that relatively easy, even though many times we get objections that it's irrelevant. It actually is not irrelevant. It goes right to the specific issue with regards to the statute. And it's very helpful to the jury because it comes across as an independent spokesman talking about all the wonderful things that they do. So what happens is the case is then tried. And of course, there's the various post-verdict motions. But before the case is submitted to the jury, we also, during the charge conference, you will argue that there's insufficient evidence to be able to support a jury finding with regards to that particular special issues that would have circumvented the cap. So those things are very important. And the other thing I want to talk about is, for an example, some of the issues with regards to insurance limits. For example, if you have a case and with there's multiple plaintiffs and there's allegations of sexual abuse, for instance, against a youth pastor, as it says in the slide, and the religious organization has the requisite insurance of the 500,000 and $1 million per occurrence. Most insurance companies take the position, we're in great shape, we're liable for only for $500,000. And that's what our insureds would think. And that's what their outside counsel. But there's starting to be an effective argument that's made that if some payments are made early on, you settle with some groups of plaintiffs in that case, and it dilutes or it depletes the insurance coverage so that you have 4 or 5 additional plaintiffs who are abused by the same youth minister, the insurance is no longer in effect and the caps aren't applicable. Unfortunately, we have no case law on that. And the plaintiffs have gone back to the statute. And if you remember early on, I mentioned the insurance requirements were 500,000 at least, the word least, at least 500,000 or 100,000. So, I mean, an effective argument could be made that when this insurance is placed, you ought to have more. It could be $1 million, $2 million, it could be $3 million, $6 million, if it can be afforded. The other thing you have to look into the policy is the definition of how you define a single act. If it's one actor, one youth pastor, it may have abused many victims over 2 or 3 policy periods. That's considered one incident and one act, and one policy limits are applicable. So these are cases and these are issues that I deal with almost on a daily basis. I have, I don't know, probably 60 of these cases that are pending. And from a practical standpoint, what I do when we go to mediation, I put together a brief and provide it to the mediator so he can, when we do our mediations in Texas, parties are in separate rooms and the mediator goes back and forth to the rooms. You can put this information together for a mediator, and it typically is not applicable, or it's not very impressive to the plaintiff's attorneys, but I've been told many occasions by the mediators that the actual plaintiffs themselves become very concerned with regards to with the caps and the lack of information from the appellate court, direction from the appellate court, and we continue to have some degree of reasonable success in settling these cases if the facts merit that during the mediation process. So one of the things I want to leave you with today is that if particularly for brotherhood, that if for the cases that you have pending in Texas, if you think you have a cap in place, it is not a panacea. The plaintiff's attorneys are becoming increasingly sophisticated on how to circumvent those caps, and it really expose your insured. So please keep that in mind, and thank you for allowing me to present my thoughts to you this morning.
And I think next up we have Shea to close out this presentation on COVID-19 immunities. Shea, would you like to have control of this PowerPoint?
I'm fine with that.
Okay.
I almost forgot to request control. There we go. So kind of some fun background to me. Not only am I an attorney in Nevada and also a legal member, but I also serve in my state's legislature. So I wanted to, I don't think I have this control. Sorry about that. There we go. I found this topic pretty interesting just because of recent special sessions in my state requiring the need to address business immunities with COVID-19, just getting the economies back up and working. And so kind of taking a step back is, I'm sure most states that are used to emergencies are familiar with federal guidelines that already impose immunities to protect those that are providing countermeasures as to a means to have immunity. So just going back, already in federal law from 2005 was the Public Readiness and Emergency Act, known as PREP, which provides for there to be immunities. And as soon as Secretary Azar declared a public health emergency with respect to the coronavirus pandemic, declared on January 31st, 2020, already in place started to be triggering those PrEP immunities. And it's really like in our situation, looking at the COVID-19 situation would be from like testing or trying to address the issues pertaining to the pandemic as opposed to the broader sense of like business community reopening. In this situation, the federal law does have an exception for willful misconduct. I go back to the cute little cartoon that Mr. Hudson had put up earlier where the guy took out the ovary and claimed immunity. So obviously with this, there can't be any improper or willful misconduct associated with addressing COVID-19 pandemic. I thought I overshot it. Also, a later law in 2013 extended the immunities to start addressing products and technology. So we're seeing everywhere that pharma is looking at ways to implement vaccines, items like that. So I think it'll be interesting to see down the road what those immunities could entail should there ever be lawsuits once vaccines start getting implemented, and seeing what may result from that. Then we get the CARES Act, which for most people, the CARES Act was the monetary relief. In there, they also expanded immunity specifically to address the respirators that were being used and still being used as to be defined as a countermeasure. And also in that, we started to see there was the qualified immunity for the healthcare workers. And so most states, which I'm sure other states that usually have have other events, whether it's weather, already dealing with emergency management, are familiar with. I come from a state, Nevada, where we have very little emergency situations warranting a shutdown, just good weather, good climate. But in this situation, obviously, we had a state shut down, and it came to fruition that we have laws stemming back into the early 50s that anticipated immunities for those emergency management. And so most states, and there's a list of this, that already had in place immunity laws for the healthcare professionals that would be addressing emergencies. David, sorry, I'm having issues.
Oh, I can help you.
I'm back to the other one. Sorry about that. My little turny thing's not working. So then also one fascinating thing is a lot of the news pertain to beyond healthcare workers who are treating for coronavirus. A lot of the news was capturing that our skilled nursing facilities and long-term care facilities were experiencing higher outbreaks within, I believe it was like Washington, where you saw multiple skilled nursing facilities that had lots of outbreaks. And Michigan, actually as part of their executive order from their governor, specifically addressed immunities for those in the skilled nursing for COVID-19 response. That's kind of more of the exception than the rule. We can go to the next slide.
Sure.
Sorry about that. I don't know why I'm having.
No worries.
So, thank you. So for the COVID-19 state immunities, looking to state law, what was also happening in addition to not only having laws in place, statutes to address emergency management, but also a lot of the governors started issuing executive orders. And this spanned from providing protections for further protections for healthcare or essential workers, just expanding beyond those statutory provisions. And so with this one, if you could just click once, it's just going to do a fly-in. I thought it'd be fun. I pulled from the state of Nevada, the executive order from our governor, wherein the emergency was declared March 12th, but it was not until about April 1st, 2020, when the governor expanded immunities for healthcare professionals. And that could also be, in Nevada, we also have religious hospitals that are actually owned by religious nonprofits. And so I thought this would be kind of pertinent with respect to those healthcare professionals who are on the front line and addressing the COVID-19 pandemic and remedies for the people coming into the hospital. So it expanded the immunities for those on the front lines. We can go to the next. Okay, and so really getting to what's probably most important for your insureds in cases that may arise if COVID-19 contraction suits start to arise is the move towards immunity for businesses. And I really should have called this person immunity because I feel that most of these statutes that have been implemented focus on persons. And under this statutes, persons include corporations. It is a breadth of business entities, including individuals. And so when looking at the 6 states, the first 5 were North Carolina, Louisiana, Oklahoma, Wyoming, and Utah. And it wasn't just till I think basically barely less than a month ago, Nevada was added to this. There are 2 other states that have bills that are kind of floating out there, Arizona and Kansas. In Kansas, the bill is right now pending before the Senate, and in Arizona, the governor vetoed it, and I wasn't sure what else was attached to that, but that went back to their state assembly. And they all kind of stem all over the place. There's not a simple blanket immunity that says if someone contracts COVID-19 at any place of business, you're wholly immune from suit. Instead, most, just like the federal law, are making exceptions where there's willful misconduct, reckless, and that varies. Some states, such as the state of Nevada, goes down to gross negligence as being an exception. But in Utah probably has the broadest immunity for businesses or any, it is everything. So it would include also religious organizations. It has the broadest immunity, and it only would not apply if there was willful misconduct. I've seen a lot of legal articles right now where lawyers are making the argument that if you're not following guidelines such as mandating masks or social distancing, that could be a willful misconduct. But it'll be interesting to see, especially when I think about what was passed in Nevada. But North Carolina it excludes grossly negligent or intentional acts. Once again, now you're looking at whether the compelling health standards, or it will be interesting to see. But in my mind as a litigator, when I was seeing these various statutes, I was already starting to draft complaints because it does seem a little easy when you're just saying, we're going to exclude willful misconduct. And looking around, and if the common rules or whatever may be controlling that industry aren't being followed, I was just always imagining, I'm sure someone could find somewhere some document pertaining to best practices for a business to prevent the spread of COVID-19 to highlight. I just already saw the depositions going, the cross-examination of everything that business didn't do, and to make those arguments that there was intentional non-compliance statute. With the controlling health standards. In Wyoming, it was interesting. Wyoming looks at any person or business entity who acts in good faith in responding to COVID-19 health emergencies. This, I thought it's interesting now when you start putting other terminology in it, because now it doesn't make it as simple as black and white. There's going to be more room where the immunity may or may not apply, and obviously the courts will be more involved with that. Likewise, the other interesting was Oklahoma, and I didn't put all these on here, but Oklahoma was looking at acts or admissions alleged to violate a duty of care of the profession in compliance or consistent with federal state regulations. So that adds another whole layer. Louisiana just obviously is back to provides immunity unless a business fails to comply with COVID-19 federal, state, or local guidance. But just there is so much out there, and I knew this was a heated debate in Nevada. I kind of look at Nevada as like the hybrid. It was a part, very long bill. I think it only passed our state because it was tied with a workers' rights bill to address tourism for Nevada. Businesses had to get back. Tourism had to open back up. Our state economy would have been devastated. And so the bill pushed to make sure our culinary workers on the Strip were being protected for it. And on the back end, looking to provide immunities to those business establishments. But what's interesting in Nevada that I think is important for Brotherhood Mutual is the encompassing of the rule. The rule was broken down to 3 components. Instead of all persons, it addressed specifically businesses for profit, government entities, and nonprofits. Inclusive and nonprofits is included specifically in the statute. It will provide for religious organizations. But the interesting thing under that is for nonprofits, hospitals are excluded, skilled nursing facilities are excluded. And in Nevada, we have a lot of religiously owned nonprofit hospitals. And so those would be excluded from the immunity. So they're just held to the normal standard. However, you got to go back and look at our executive order from the governor extending immunities to healthcare professionals. So there's kind of that balance, but the other interesting key component to take from this is on the education of the schools. While government K through 12 schools, public schools are excluded, they are included for nonprofit religious organizations for purposes of immunity.
So thank you again for joining us. All of us here at Eagle are enthusiastic about putting these programs on and interacting with you. So if you have any feedback for us, please let us know. Reach out to us at the website at www.eagle-law.com or to any individual that is a member. We're happy to talk with you, happy to get your input, any feedback, criticism you may have. If you have questions about the program, ideas about future conferences that you'd be interested in, we're happy to engage and talk with you about that. So thank you again for joining us. We hope you enjoyed it. We look forward to seeing you soon. Thank you.